All right. Well, thank you for doing that. Let's get stuck into it. My name's Maurie and Annese. I'm a business development manager here at Citation, and I'm joined with Corrina Dowling, who's one of the senior partners at Citation Legal. Today, we're talking about surviving the new IR rules and what SMEs need to do now to prepare for the changes. Now, before we kick off, just a few housekeeping items. If you do have questions throughout the sessions, please use the Q&A feature at the bottom of your screen, not the chat box. We'll be answering your questions at the end of the session. Now, you don't need to wait, so feel free to submit your questions as we go throughout the session. And yes, it is being recorded, so we'll send you the recording to the link for everyone who's registered, so keep an eye in your inbox for that, or your junk mail potentially. Now, we've got a great turnout today, which tells me that this topic is front of mind for a lot of businesses right now. I meet many businesses who are scrambling to catch up from changes that were made, several months or several years ago. And it's just disappointing how little information there is out there proactively from Fair Work Australia and other bodies that keep you in the loop with these things. And the pace of IR in Australia over the last 18 months the changes have been significant, and keeping up with it and what's already in effect, what's coming, and what it means practically is no small task for business owners, which is where we come into it. We like to offer a lot of goodwill with these webinars, and of course, we're on call for you should you want to call us for any advice. Feel free to ask myself. I'd be happy to offer some advice around some of these changes, and of course, Corrina as well. By the time we finish today, you'll have a clear picture of the changes and what matters most to your business, and some practical tips that you can take with you to get on the front foot. And now joining me today is Corrina Dowling from our Melbourne office. She's a partner in Citation Legal. She's a highly regarded workplace relations lawyer with almost 20 years of experience across employment law, fair work compliance, and industrial relations. She's worked with businesses of all sizes across Australia and has been helping Australian businesses understand and respond to IR reforms that we're covering today. So welcome, Corrina. Thank you for being here. I'm sure I'm probably going to learn a lot myself. Now, before we get into the content, just very quickly, just want to have a chat about Citation Group's ecosystem. We are across many different sort of services. I work in offering HR and health and safety compliance services to small to medium businesses. So I do review, I consult, and of course we do have services that you can tap into to become an extension or indeed new HR or health and safety departments within your business. So there's Citation, all the health and safety legislation across Australia. We are completely over. We've been doing this work for over 30 years, and we're very well regarded. We're the leaders in representing and supporting associations around Australia. Certification, ISO certification is a big part of our company. It's a separate group. So for clients that I meet, I refer them to the ISO team, and then they can get a quote on what it means to become ISO certified under all those numbers. FoundYou is a business that we recently acquired. Now, this is a payroll, time and attendance software system that can be tailored to your business. So it's one of the leading payroll and time and attendance functions. It talks to Xero, integrates with Xero, as our HR and health and safety software does. Xero and MyOb, I think, are the two main softwares that it integrates with. We'll be more than happy to chat with any of you around our services if you feel like you do need support. Obviously, there's no obligation. It's just potentially a meeting with me or from a member of our other group of companies to kind of assess your needs and then get back to you with a tailored quote. And Citation Legal, of course, have not just employment law, but also an immigration law firm attached to it. And we get many clients that approach us around migration law. So it's literally one-stop shop for a lot of your needs. As I said, we're happy to give you some free advice as well. So don't call Fair Work Australia or Work Health and Safety Body. Please call us and we'll be able to get the answers you need with obviously no obligation of you becoming a member. Most of the time when people do call me for support, it does lead to them wanting a solution because, the workload is too large for them to tackle themselves. And of course, you need to nail it. It needs to be, technically drafted in terms of contracts and policies and in line with the legislative changes, which we understand very well. So feel free to contact us. We'll get into today's content now. So over to you, Corrina. Thank you so much. And we'll be in contact after Corrina's presentation.
Thanks, Maurie, and thanks everyone for joining us this afternoon. I'm sure you've got a lot on your plate, so hopefully this session provides you with some helpful information. Hopefully it's not too scary, and hopefully you also take away some practical things to implement in your own business or organisation to make sure that you are meeting these requirements. And look, to be honest, the obligations and liability on employers seems to be increasing year on year. So compliance is a massive issue, obviously, with liability that attaches to it. So being here today is a really good step to making sure that you understand what's going on in the IR world. So on that note, the agenda today is pretty packed. I'm going to try and get through a lot. And obviously, as Maurie said, if you have questions, please pop them in the Q&A box and we'll try and get to as many as we can. If we don't get to them or you think of something after the fact, please reach out to us. So today's agenda, we'll be looking at what some of the key IR reforms are at the moment. So there have been significant changes in the previous 2 years in particular, and those changes are still coming. So we'll go through what those changes are with a particular focus on wage theft, a decision in the annualised salary space and payroll compliance. This is really a big issue for employers and one that there's significant focus on from the Fair Work Ombudsman in particular. So we'll do a bit of a dive into that as well. Having a look at some new rules that are coming into play either this year or potentially next around NDAs for Victoria, non-competes and leave entitlements. And then, as I said, we'll touch on your questions. So without further ado, let's get into it, and starting with the issue of annualised salaries. So late last year, the Federal Court handed down a very long-awaited decision in a matter brought by the Fair Work Ombudsman against Coles and Woolworths, so obviously the big hitters in the supermarket space. The background to this, and anyone who has sort of been using contracts for a while would be aware that it has been a very, very common practice for annualised salary employees to have an offset clause in your contract. And certainly any advice you would have got in recent times would have been you must have an offset clause for your annualised salary, which essentially means that you agree to pay someone an annual rate and you get to offset that over the course of the year. So it works really well for employers that have seasonal demands. So you might front load an employee, so they might be getting quote unquote overpaid for a part of the year, and then extra hours kick in and it all balances out in the end. So it was a really, I suppose, easy way to manage staff from an administrative perspective over a year. This case turns that very historical practice on its head. So there's a provision in the Fair Work Act that says that employee has to be paid at least monthly. And then there are award and enterprise agreement provisions that might make that frequency even shorter. What this decision said was that when you are checking whether the salary is sufficient to cover award or agreement entitlements, you can't do that process over the course of a year. It must be done after each pay period. So it means that, again, for those employers that need to, that have seasonal demands, you can't front end or backload the hours that are worked. You must make sure that every pay period, that salaried employee is receiving equal to or greater than what they would have received under the award or the enterprise agreement. So this is a massive shift. Obviously gives rise to a considerable risk of underpayments if you're not doing that, essentially an audit process, or your salary is just, miles ahead of what the entitlements can possibly be. So it is a really, in some ways, controversial decision. It is under appeal, but as it stands at the moment, this is the law. And what the court also said is that annualised salaried employees are still obviously covered by the record keeping requirements. So that means for your salaried employees, you do need to be recording their hours of work, in particular their OT. So even if their salary is high enough to cover a certain amount of OT, your records need to demonstrate the start and finish times of that overtime. So it is a really good time for employers to be checking their payroll systems, their time recording systems, and making sure that you are meeting those requirements so that you're not going to fall foul of this decision, subject to obviously the appeal being heard and decided. It may be decided in the same way, but as I said, as it stands, this is currently the law. So that's probably a good segue then into the Fair Work Ombudsman's payroll remediation guide. So Fair Work Ombudsman is obviously the regulatory body that will investigate and potentially prosecute employers for failure to meet minimum entitlements under awards or under the Act in terms of wages. So they issued a remediation guide in mid last year, and that provides employers with a framework for what to do essentially if you identify an underpayment within the workplace. And this relates, I suppose, to the decision as to whether you voluntarily notify the Ombudsman of an underpayment. And in most cases, that's probably the better approach to take, but do get advice. So if you are going to do that, it's a good idea to have a look at the remediation guide, or whether or not you are, and comply with that if you can. So the Ombudsman will consider what remediation steps an employer has taken when they're determining what to do with you. So basically, this will be viewed quite highly. If you come to them and say, we've made an error, we've identified it, here's our PRP, our payroll remediation program, following the guide, and that will weigh quite heavily for the Ombudsman in deciding what to do. Complying with a PRP does not mean that they won't prosecute, but again, it does provide a basis for them not to. So it's a good practice in any event. So in terms of what that PRP proposes or recommends, there are some key elements that the Ombudsman will be looking for. So firstly, designing the framework of your PRP. What's the scope? Is it limited to a particular issue that you've identified? Maybe it's an allowance that wasn't paid or an incorrect interpretation of overtime, or are you doing an end-to-end payroll review because there are systemic issues? What period are you looking at reviewing? Was it a discrete period of time so you can justify a shorter period? Under the Act, underpayment claims are limited to 6 years. Interestingly, though, this remediation guide, the Ombudsman says that employers should be going back as far as possible. So their expectation is that an employer who identifies a long-running issue will go back as far as possible, which, given you have to keep records for 7 years, they don't have a date in there, but they would be seeking that you would go back even further, even though a court couldn't enforce any underpayment beyond the 6 years. So that's an interesting little inclusion that they've put in there. They'll also look at your communication, so how you're communicating to staff, including former staff as well. So making sure that there is open and transparent communication, how you're going to make the payments to staff. Again, the expectation of the Ombudsman, at least in accordance with this guide, is that any underpayments will also be paid interest on top of those. Again, that's not something that the Ombudsman could ever enforce. It's only the court that can require you to pay interest on underpayments. But again, it's the FWO's expectation that any employees who have been underpaid have been paid interest. You do need to track down former employees. So they want to know how you're communicating, how you're reaching out, what attempts you've made, what you're doing to find those former employees. And then finally, what action are you going to take in the future to make sure that this doesn't happen again? So all of those things will be taken into account by the Ombudsman in determining whether they potentially issue a warning, maybe they require you to enter into enforceable undertakes, or whether they do, regardless, decide to proceed down the prosecution path. So regardless of that, this is very much a good practice guide, and certainly we do a significant amount of payroll audits and compliance audits as part of Citation Legal, and this has really always been our recommended scope. Not potentially some of the extra added goodies that the Ombudsman puts in, but broadly speaking, this is a best practice framework that has been formalised through the Remediation Guide. So moving then to the issue of wage theft, so you can see a bit of a theme going on here. And as I said before, the compliance piece around wages, criminalising wage theft, the remediation guide being introduced, this is a massive focus for the Ombudsman and indeed the courts. And because of the significant growth in wage scandals, really, and across really big brands, in a range of industries, hospitality, franchise, retail, aged care, the government obviously wanted to make it or impose an even bigger disincentive for engaging in this type of conduct. And it is really quite serious when employees are having their wages intentionally withheld from them. So wage theft provisions commenced on 1 January last year through the Closing the Loopholes Act. It occurs where an employer commits a criminal offence where they have a requirement to pay wages, entitlements, any of those sort of characterisation of entitlements to an employee, and they have intentionally done something that results in those amounts not being paid on the day they were due. So there's obviously an element of intent and knowledge here. So there is a relatively high threshold, but there's certainly been some cases in the past, had these provisions been in place, that they almost certainly would have fallen foul of these provisions. So there are very, very significant penalties. There haven't been any prosecutions at the federal level yet, but I understand that there are some processes occurring in the background where those matters are being prepared for prosecution. So where there is a prosecution, a successful prosecution, individuals are looking at up to 10 years imprisonment. So it just goes to show how incredibly serious this issue is. On top of that, the fines are absolutely extraordinary for an individual involved in criminal wage theft. It's around, sort of included the number, it's 1.65 million or 3 times the underpayment amount, whichever is greater. And for corporations, it's around $8.2 million for a penalty or 3 times the underpayment, whichever is greater. So this is incredibly serious. Obviously, I would hope that there are very few employers out there who are intentionally engaging in this type of conduct. But again, it's a reminder to just making sure you have crossed your T's, dotted your I's, and making sure that you are complying with these requirements. Where you identify an underpayment, and look, maybe there was some element of intent, but there might be an explanation for it, you can voluntarily provide that information to the Ombudsman again and seek to enter into a cooperation agreement with the Ombudsman. If they agree to that, and that's the risk, they don't have to, if they agree to enter into that agreement with you, then they are then essentially barred from referring the matter for criminal prosecution. And that's the other thing to keep in mind. So the Ombudsman can refer for prosecution, but they obviously aren't a criminal body. They're a regulatory body, so they refer it to the AFP or the Department of Public Prosecutions, and they have to decide if they're going to press on with it. But if you make that agreement with the Ombudsman, then they can't refer it for prosecution. They can still take other enforcement actions. So even if you have a cooperation agreement, they can still commence civil proceedings or seek to engage in enforceable undertakings, those sorts of things as well. There is also a special carve-out for a small business. So there is a small business wage compliance code If you can demonstrate that you're a small business, first of all, and that you've complied with the code, then again, if the Ombudsman is satisfied with that, then you won't be referred, or you can't be referred for criminal prosecution. So small businesses should absolutely be having a look at that compliance code. And again, it's simply good practice in terms of what they require under that code. It's about taking reasonable steps. So what do you have in place to check that what you're paying is correct? Are you pulling the pay guides from the Ombudsman? Are you seeking advice? Have you got a payroll system that can do these checks? Do you have an advisor, an HR subscription advisor where you can call up and check these kinds of things? They're also a really great resource, obviously, for keeping you up to date. So letting you know that, hey, there's been award changes. We're going to touch on some award changes very shortly. The junior rates have just changed. The minimum wage decision has been handed down. How are you keeping yourself informed? When you do have issues, what are you doing to fix them? What advice are you seeking? Is that advice reliable? So, chucking your payroll into ChatGPT or asking, AI to review your payroll practices probably isn't going to be considered reliable advice. So do seek out a reputable provider to provide you with that advice around what interpretation issues are, what you should be doing, how to fix it, and absolutely cooperate with the Ombudsman and seek advice while you do that. So moving then to hopefully something a little less scary, we'll have a look at government-funded parental leave changes. So in Australia, there are essentially three types of parental leave available to employees. Obviously, we're talking the federal level. So there's unpaid parental leave under the Fair Work Act. Then we have government-funded parental leave under the Paid Parental Leave Act. And then there's the possibility of employer-funded parental leave. That's obviously not compulsory in Australia, but we're certainly seeing quite a significant uptake in the amount of employers offering paid parental leave nowadays. So it has become, I suppose, a recruitment tool to encourage people to come along. So the increase to government-funded parental leave has been done in stages incrementally since July 2023. So this year we'll see our final increase in the government-funded paid parental leave up to the 26-week mark. So not something that employers obviously need to be too concerned about in terms of the financial impact. This is government funded, but still relevant for your staff to know about that. This other change has been the number of days that the partner can take. So that's again been incrementally increased. And at July 2026 this year, it will hit the 20 days. So the bigger change really in this area is the employer-funded paid parental leave, if that is something that you do offer or you're thinking of offering in the future. So the data on this is that around 68% of private employers currently offer paid parental leave, and 87% of those pay super on it as well. The issue that has arisen and has resulted in some changes to legislation around employer-funded parental leave came about with a very, very sad situation a couple of years ago, where a baby was born and very, very sadly died at 6 weeks of age. Now, baby Priya's mother had employer-funded paid parental leave. When she notified her employer that her baby had very sadly passed on, the employer cancelled her pre-approved paid parental leave, her employer-funded paid parental leave, but did offer her 4 weeks of personal leave instead. So there's no criticism of the employer here. What they did wasn't unlawful. But what this did was, I suppose, invoke a discussion about what kind of support we're providing to employees when, the unthinkable happens. So as a result of that, some changes or new legislation was introduced. That provides that where an employee would have been entitled to paid parental leave had the child not been stillborn or died, then they retain the benefit of that type of leave if their child does pass on in those circumstances. So it doesn't apply where there was already a policy in existence pre-November last year that explicitly dealt with the ability to refuse or cancel in those circumstances. But any new policies or policies that didn't deal with it, this will be the requirement moving forward. It doesn't affect other entitlements to under the NES to compassionate leave and unpaid parental leave and all of those sorts of things. So it was always the case that a stillborn birth didn't affect unpaid parental leave or government parental leave. So it's really bringing the privately funded system in line with those other two entitlements. So moving on now to some slightly different topics. So WGEA target setting. So this is for the big employers on the line, I suppose. So the aim of the target setting requirements has really come about to try and accelerate the progress on achieving key gender equality metrics in the private sector. So what it requires employers with 500 or more employees to do is to identify some targets that you want to achieve. So there's a list of targets that are available to you, and they're going to be a range of numeric targets or otherwise. You do have to have a selection of those targets. So at least one has to be numeric. So it might be we want to get 50-50 split of senior managers on our exec board by whatever date you set in the next 3 years. So there has to be a range of them. And then they also have to be targets that you haven't already met. So you can't challenge yourself by proposing a target that you've actually already achieved. So pick a new target, obviously one that aligns with your business direction and your culture and all of those sorts of things. And take steps to implement those within the next 3-year period. You will be required to show a plan. How are you going to achieve that? And hopefully, even if you don't achieve it necessarily, how you're showing improvement on those categories. So the non-compliance piece will be a result. The result will be public naming and shaming of companies who haven't complied with this requirement. And again, that goes to really, impressing on employers the need to demonstrate that they are actively trying to move this forward. For the smaller employees, so 400 or less than 500, you do have to report, but you don't have to engage in the targets as the bigger companies do. So I suppose in terms of takeaway for anyone in that bigger category in particular, what to do as far as next steps. So if you haven't already, it would be worth doing, or it is, undertake a gender pay gap analysis. Engage in a consultation process, particularly with your leadership team, your exec team, to determine which targets are going to be the best fit for your organisation, and then formulate and introduce a strategy and action plan for how you're going to achieve those targets and what your milestones are going to be over the next 3 years, and really monitor that over the period. So it's not a case of, not a case of just set and forget. You need to be continuing the journey of these targets, adjust as necessary, and be confident that at the end you can justify the steps you've taken to try and achieve those particular targets that were identified. Moving then to modern award changes. So there just seems to be so much happening in this space. There are 5 major cases in particular before the Fair Work Commission. Obviously, there's a range of employers on the line, so you may not be covered by modern awards, or these particular ones aren't relevant to you, but I will just give sort of a high-level overview of where these cases are and how they may impact your business. So If we start with the first one on the screen then, so there's a degree qualified professional classification review. So this is being conducted by the Commission on a work value grounds, with the purpose being to identify whether these degree qualified roles have historically been undervalued, and whether the minimum award wages and those classification structures need to be increased to better reflect the skill and responsibility and qualifications that come with a role that requires a degree as a prerequisite. So this is largely affecting this. There's 22 modern awards that fall under this review. The most common ones that may be relevant to those on the call are the various modern awards in the education and higher education industry and the Professional Employees Award. So if any of those apply to your business, then just keep an eye out for any developments in that space. The case is still very much underway. And we're waiting for next steps on what the Commission's going to do, whether there's more questions for the parties or whether it's going to move to a hearing stage to make a decision. The next one there is the General Retail Industry Award. So the Commission has joined together quite a few different applications to vary the General Retail Industry Awards. They're going to be heard at the same time. Again, it's ongoing. If you're in the retail industry, you would probably have a lot of information about this already, but just very broadly, it's in relation to overtime, penalty rates, entitlements, rostering arrangements. So again, we've heard submissions in reply have been filed, and we're just waiting on next steps again. Junior rates. This one is very, very timely because the decision was actually handed down yesterday. So the review came about through an application from the SDA. They made an application to vary the minimum rates for junior employees. And look, their argument, I'm going to distill this very simply, and it was much more broad and articulate than I'm going to give them credit for, but it essentially was the junior structure in modern awards is archaic. They've been around for 50 or so years. There's no basis anymore for anyone under or over 18 to be paid a junior rate. So at the moment, junior rates apply up until 20 years of age, depending on the award. So it means that you can be an 18, 19, 20-year-old and be receiving a proportion of the adult rate, but you can drink, go to war. You don't get a discount on your rent or your petrol or your other living costs. So why do they get a deduction on their wage rates? So they also wanted to increase the actual amounts, the actual percentages for juniors under 18. The Commission has said no to that, but they have agreed that moving forward, the junior rates from 18 and above will be removed over time. So it is going to be a process, and there are some caveats around length of service and things like that. But that is a very big decision that we're sort of just hearing about. As I said yesterday, it was handed down, so we're still digesting the decision in that regard. The other review that's happening is in relation to part-time provisions across a range of modern awards. This one was commenced on the Fair Work Commission's own initiative. It's looking at 11 different modern awards to consider the possibility of introducing a model term for part-timers. So that would make sure that there's consistency across the definition of what is part-time employment, distinguishing it from casuals, agreed variations to hours, minimum hours, those sorts of things. So look, I think there's absolutely merit in having consistency across the awards. I mean, that was the whole idea of, for those who are old enough to remember it, the move from the old NAPSs to modern awards was to reduce the number of awards and have some consistency. So for an employers who are operating across multiple awards, I think consistency is a wonderful thing, subject to what they choose to implement as the model term though. So again, watch this space in terms of where this review ends up. Then finally, there's a gender-based undervaluation process being undertaken. So again, commenced by the Fair Work Commission. They are reviewing the classifications and the minimum rates on work value grounds to identify and, where appropriate, remedy any gender-based undervaluation. So the expert panel has started with 5 priority awards. So they're up on the screen there. And there's already some changes coming through in relation to those awards. Again, because it might not apply to everyone, and it wouldn't apply to everyone. I'm not going to go through those details, but if any of those awards apply to you, then absolutely reach out, make sure that you're aware of the changes that have been already implemented in relation to those particular awards. There have been changes to classifications and to pay rates as well. So make sure that you are on top of that as well. Okay, moving on then to Payday superannuation. So still in the realms of pay. So I'm sure any employer on the line knows the current state of play is that employers are required to pay 12% super contributions at least every 3 months or quarterly into the employee's nominated superannuation account. And if you don't comply with that, then it can be a breach of the Fair Work Act, potentially of the award or your EA, and of course super guarantee charges can apply as well. So a review last year identified through the ATO that there were in fact billions of dollars in unpaid superannuation each year, and the government identified that a change to the requirement in terms of timing of payment of superannuation would improve the integrity and the efficiency of the superannuation system. So essentially, they're trying to close the gap to make sure that employees are receiving what they're entitled to. So the result is Payday superannuation. So what this means is from 1 July 2026, employers will be required to pay their employees super contribution at the same time that they pay their salary or wages. So that's obviously going to vary depending on what your pay frequency for your staff is, whether that's weekly, fortnightly, or monthly, or something in between. And it also might mean that you have different employees on different pay cycles. So you're going to need to adjust your payroll or making sure that your super is being paid in accordance with those varying pay cycles. The other requirement, there's a 7-day window. So you pay it on the payday, and then there's essentially 7 days, 7 days grace to make sure that those funds hit the super fund within 7 days. So overall, this is a really significant move. This is obviously a system that's been in place for a very long time. So it's going to be a lot of change for businesses. There are potentially going to be ramifications for businesses, not even in terms of compliance, but the biggest issue for some might actually be cash flow, particularly for SMEs. You might have been relying on, that quarterly time frame to make sure that you're getting your bills paid. Your suppliers or your clients rather are paying your invoices so that you've got the funds to then process that superannuation payment. So you are going to need to make sure that you've got that cash flow adjusted, or you've got reserves so that you can make those superannuation payments on that more regular basis. The second impact that we see is on your systems, making sure that your payroll systems are adequate so you can hopefully transfer to this new requirement relatively easy come 1 July 2026. If you've got an automated payroll system that can, you can adjust to dictate when the superannuation payment is transferred, then great, that should make it a lot easier for you. And keeping in mind as well that if those funds don't hit the superannuation fund within 7 days, again, that superannuation charge is going to be payable. So it's going to be really important to make sure that that time frame is appropriate. So in the lead up to this, absolutely be checking that your payroll system can handle this change, and that whatever changes you need to make in the back end, or if you need to tell your bookkeeper, to make sure that this change is implemented from 1 July 2026. Train your payroll staff so that they're aware of this, they understand how critical it is to get this right, and engage with the super funds as well. You would hope that 7 days is more than sufficient for funds to transfer. I think when money's coming out of our accounts, it seems to be instant, but hitting on the other side for some reason seems to take a bit of time. So liaise with those super funds to make sure that that's actually going to be sufficient time to hit their funds. There are two very limited exceptions to these rules. So the first is for any new employee. So you have new staff coming on board post 1 July 2026. You are given an extra grace period of 20 business days to make sure that their superannuation is paid. And after that period, you will be expected to get them in line with your ordinary payroll process so that they're being paid on their day of payment as well. And then the other exception is for small and irregular payments. So these are things that are payments outside the normal pay cycle. It might be a bonus, an ad hoc allowance, something that's not paid in accordance with that regular cycle. Then it doesn't trigger the immediate requirement to pay super, but you will need to pay it during the next regular pay cycle. So again, you get a relatively small grace period. And again, if you don't comply with that, you will be hit with the superannuation guarantee charge. And again, potential breaches of the Fair Work Act and the enterprise agreement or modern award that applies to your business. Conscious of time, we've still got a bit to get through, so hopefully I'm not rushing too much for all of you, and this is all making sense. Moving now to restrictions in NDAs in sexual harassment cases. This is an Australian first. At this stage, it only applies to Victoria, but that's not to say that it's not going to extend to other jurisdictions. So this is, again, legislation that passed through late last year. Government was very busy late last year passing new laws for us. The aim of the legislation is to make it unlawful to enter into a non-disclosure agreement where parties are settling a sexual harassment claim. The impetus for this is that it centres around the idea that these non-disclosure agreements or confidentiality clauses in settlement agreements have the effect of silencing victims. And there is some research around, a number of around victims of sexual harassment and sexual abuse signing these agreements, and then it can be years down the track where they realise that those agreements have impacted their ability to recover or have adversely or continued to affect their trauma and those sorts of considerations. So the purpose is to, well, I think it's probably twofold. Employers across the country already have a positive duty to prevent sexual harassment in the workplace. So this is, I think, a bit of a stick. Because certainly we haven't seen a lot of change in behaviours or actions from employers when that positive duty came in. So this is a stick to say, if you don't get this sorted and stop this behaviour from occurring in the first place, where it does occur, you cannot hide from it. You cannot pay a sum of money and get that person to sign a confidentiality agreement, and all of this goes away. So there's that side of it, in addition to obviously the ability for an individual to be able to do what they need to do to recover. And if that means talking about what happened to them, then that's seen as a positive thing. So there are some exceptions to having a confidentiality agreement or a non-disclosure agreement. There are very strict preconditions that have to be met. So firstly, it has to be the complainant who requests to enter into an NDA or confidentiality clause. It has to be their express wish and preference. So that's not to say that in the course of settlement discussions, it can't be raised by another party, but it would need to be done very, very carefully, and perhaps more along the lines of a query to the applicant or the complainant as to whether that's something that they do want. So it has to be driven essentially by the complainant. They have to be given a copy. It's not available yet, it's being produced, but there will be a workplace non-disclosure agreement information statement. So very much along the lines of the Fair Work information statement, it will be, I presume, a statement that sets out the complainant's entitlements in under this particular legislation, so that they're making an informed decision about whether they want to enter into this NDA or not. And it will talk about, obviously, their right to obtain legal advice and terminate the NDA and all of those sorts of things. Once they have the agreement, the information statement and the proposed NDA, they have to have at least 21 days to review and consider that. So that's to make sure they've got the opportunity to obtain legal advice, think about whether that's really what they want to do. They can waive that period, but again, that's purely in the hands of the complainant as to whether they want to do that. And then there's going to be a pro forma document that each party has to acknowledge that each of those preconditions have been met. So it's going to be difficult, and I think that was probably intentional, to get an agreement that incorporates a confidentiality piece. What is going to be really interesting to see is that, and not to say that, all claims are unmeritorious or anything like that. In my very long years of doing this, I have seen a mixture of both. There are certainly claims that don't have a lot of legs, but they are resolved by the employer because they just want it to go away. They don't want to spend time and resources, and they don't want their reputation dragged through the mud, even if they think that they can successfully defend it. Mud sticks. And when a serious claim like this is made against you, it's very difficult to walk back from that. So a lot of employers that I've worked with in the past have agreed to settlements only on the basis that it's subject to confidentiality. That was really the driving force. So it's going to be interesting to see if that changes the approach to litigation and what that means for individual complainants that maybe say, look, and let's say this is a legitimate claim where they don't want confidentiality, but they similarly don't want to run through proceedings, because that can be equally as traumatic, to be on the stand and have to, give evidence around these things. So that's a bit of a tension between, the interests of the parties and what the law says. So it's going to be interesting to see how this plays out when, we start to see these matters come through, given that it's not in effect yet. Just another note as well, that they can be terminated as well. So after 12 months, the complainant can terminate with 7 days' notice. I only have a couple more slides. I'm conscious that I'm running out of time. I should always prepare people that I can talk about this stuff for hours. Very, very quickly, restrictions on non-compete clauses. This is not in place yet. The government's been talking about it for a long, long time. It is expected that legislation will be introduced to come into effect next year that will prevent employers from including non-compete clauses, so stopping their employees from going and working for a competitor where that employee is paid under the high income threshold. So very, very important change, not in effect yet, but watch this space. I'll quickly move on to the big National Employment Standards review. The National Employment Standards haven't been reviewed since the Act commenced in 2009. So the review panel is now looking at whether the NES is still fit for purpose, essentially. So as you can imagine, there is a laundry list of things that the unions would like changed, all of them increasing entitlements, thus increasing costs for business. That's not to say these will be approved, but the government is looking at things like increasing annual leave to 25 days a year, changing the redundancy entitlements to possibly remove the small business exemption. So at the moment, anyone who employs under 15 employees doesn't have to pay redundancy pay, so that might be removed. There's going to be a big focus on redundancy, I would think, because of the introduction of AI, and there's significant concern about the impact that's going to have on employment and potential redundancy situations. So, again, no changes yet. Watch this space, and yeah, we'll keep you updated on that. So, I'm very sorry for running so late. I'll hand back to Maurie.
No, Corrina, that was fantastic. Thank you so much. That's why we're all here, to listen to your expertise. And there's so much to digest there. And I hope everyone's walking away with a much clearer picture of what's happening and what to prioritise in your business. As I said, feel free to reach out to us. There's a lot of goodwill we offer the business community. And I won't lie, it does turn into direct clients for us, but it all begins with goodwill. So don't call Fair Work. Please call us. We'll help you out. Now, before we jump into your questions, I just want to quickly look back at the poll results from the start of the session, because I think they tell an interesting story. So I'll just quickly give you an update. Only 18 respondents out of our attendees are very confident that their business is currently compliant with Australia's recent IR reforms. So that's 82% of you that are not confident. And obviously, we will be probably reaching out for some kind of support. We're well placed to give you that. Now, despite wage underpayment not being a criminal offence, 27% of respondents have taken no action to review their payroll practices, and only 35% has undertaken a full payroll audit. If we look at all those underpayment claims of the massive corporates, it was their payroll systems that let them down as well. So you can't just set and forget them. You must be on top of them. 43% of respondents consider themselves reasonably placed to face a Fair Work Ombudsman investigation, which is great, or a wage claim. However, they did admit to having some gaps around unfair dismissal, workplace disputes, followed by right to disconnect compliance, which are two of the largest concerns for employers right now. So some very consistent feedback there. And what we're offering to attendees today is a free contract review. So there's going to be a QR code that you'll see soon, and one of our team will be happy to conduct a high-level desktop audit of your current contracts and templates to identify any risks, outdated clauses, highlighting any missing or non-compete or compliant, I should say, provisions. Flagging of recent legislative impacts, including everything that Corrina has covered today, and clear, practical recommendations for remediation. So no legal jargon, just actionable insights. And of course, there's no obligation. The services that I help people or bring people on board to does incorporate a full audit and tailored contracts and policies. That it's not an additional fee. So once again, happy to reach out to you and discuss all that. I think there's a link right now that you can scan a QR code. It just takes less than a minute if you want to register your interest. There've been lots and lots of questions, and I'll try and cover off a few now. And to those that we don't answer, we will reach out to you. So please expect a call from us. If there are any, proactive questions you have for us, please give us a call. I'll just read a few of these questions, and while we've got Corrina. So one of them, Corrina, we're a business with salaried employees covered by the General Retail Industry Award. How do we know if we're actually meeting our obligations under each pay cycle?
Yeah, look, that's a great question, I think, and there's another. I'm going to incorporate a couple of questions that I've seen in the chat as well, around this idea that when you're paying a loaded rate, that basically excuses all sins under the award, and it's just not the case. As much as that would be a lovely, simple way to deal with it, it's really not. So it is a requirement to make sure that you have a system to do a check, and that needs to be a check on each pay cycle, essentially, to make sure that you are meeting the minimum requirements of the award, equal to or greater than during the course of each pay cycle. So whether you have an internal process, it might be something, given the payroll remediation guide and the voluntary compliance code, if you can outsource, and get a compliance check done, just to give you some comfort that you are meeting those requirements. That is a really important thing to do, to making sure that you are getting the correct information and you are turning your mind to whether you are meeting those individual requirements on each pay cycle.
Fantastic. One of the other queries was just around, penalties. Obviously, there's going to be a bit of lenience from the ATO in regards to Payday Super. Can you talk into that? Someone's mentioned here that they've got 12 months. They'll be monitored. So there will be a bit of a probation period, let's say,
Yeah,
Corrina?
which you would hope so, given that this is such a significant change. And there is an element, as someone has pointed out, once you've met your, compliance requirement to process it on that day, there's an element of, well, it's kind of beyond your control at that point. And if it's going to take longer than 7 days to clear, at what point is that not really your fault? And are you then required to pay super earlier than payday, which could mean that you're paying incorrect amounts? So there will be a period of monitoring these changes. And I would anticipate that there will be a grace period and perhaps some friendly reminders rather than jumping straight to immediate penalties.
Okay. Um, There's another one here that came and says, we're a small business. Do the new wage theft criminal laws actually apply to us, or is it just more for larger corporate enterprise clients or companies?
Yeah, good question. No, it does apply. So there's lots of these provisions that either have phased in timings for small business or don't apply. Wage theft is not one of them. So those wage theft rules do apply to small businesses. The carve out, though, is as I went through that small business compliance piece. So you do, if you're a small business, you do have the ability to go through essentially a checklist to demonstrate that you've done all the right things to make sure that you're trying to do the right thing, and you will then be given potentially some more leeway in terms of not being referred. But generally speaking, the laws absolutely apply across the board.
Yeah. Okay. There are certain rules, obviously, for, if your business is under 15 or more than 15 staff, and it's always been the case. But if there's more confusion or any confusion, please contact us around that. Clearing houses. So I'm not familiar with that myself, to be honest, but it says here, has there been any updates or indicator regarding the responsibility of clearing house activities for super remits? For people that have left the business but hit the receiving account late? I think that's the question.
I'm not aware of any.
Separate.
No, I'm not aware of that.
No worries. Now, another question here. We have a non-compete clause in most of our contracts. So should we be reviewing these now or wait till the legislation is finalised? Has that already been set in stone in terms of that remuneration?
Yeah, look, it's not set in stone, so there's absolutely the chance that that will change. I wouldn't have thought it would change to people under the high income threshold. So keeping in mind that the use of these kinds of non-compete clauses, the starting point for the courts is that they're already invalid. To enforce them, you need to go to the court and convince the court that they're reasonable and they don't go any further than required to protect your business. So the impetus for this proposed change is that there's been a bit of an abuse of those clauses, if you will. So
Yeah.
we've seen contracts for your local kid at a retail store working after school who has a non-compete. So you work at Kmart and you're not allowed to go and work at Target. Um,
Mm,
that's just an example. It's not real, so Kmart don't don't be
yeah.
shit. But that's just giving an example of how sort of unreasonable that is.
Yeah.
So I think it's absolutely worthwhile reviewing your contracts anyway to see, well, do I have something in there? Do I really need to? Should I just take it out anyway?
Mm,
If you do have restraints and they are a necessary part of your business, then absolutely get them reviewed. The more tailored and tight they are, the more likely they are to be enforceable. So you can't have these cut and copy restraint of trade clauses that haven't, when you haven't, turned your mind to what are you trying to protect? Who am I trying to protect? And how does this clause achieve that? So absolutely, certainly for your high level employees, best time is now to
yeah.
review those clauses in any event, regardless of those laws.
Yeah. Brilliant. There's been a few others too. And just on a general note, when I review contracts, I often see lots of policies and procedures within the contract, and that's something that we need to separate out, isn't it, Corrina? Because mandates, company mandates, and stuff around termination clauses or redundancy, they shouldn't form part of a contract, and I often see that all grouped together, which compromises the integrity of the contract.
Yeah, absolutely. Look, the incorporation of those kinds of documents creates so many issues for employers. So, firstly, once you put something in a contract, you can't change it without agreement from the person that has signed the contract with you. And then it becomes a term of the contract, which means if you breach a policy and it's part of your contract, then you technically breached the contract as well. And now we've also seen, just to add to that, that in a very big decision last year with Vision Australia, Alicia and Vision Australia, um, it was found that a disciplinary process wasn't followed. It was a part of her employment contract that it be followed. It wasn't. So it was, not only was it breach of contract, she actually received compensation for psych injury, which is a first. So if you can avoid incorporating things into your contract that just simply don't need to be there, then absolutely do that. So yeah, review your contracts, or get them reviewed if that's not a process you've done lately, particularly when we've had changes to definition of casuals. We've had these decisions handed down.
Right to disconnect, there were
Absolutely.
some recent ones.
Yeah, absolutely. And look, right to disconnect, I'm sorry, by the time, right to disconnect and flexibility are two areas that are absolutely going to continue rearing their head. And as we sort of, move towards these issues of fuel insecurity, and we've got the government saying, look, maybe we'll be recommending work from home, that sort of thing, then right to disconnect and flexibility and work health and safety are all well and truly back on the radar for how you're managing that in your business.
And with most Fair Work claims, for people who probably don't know, there's a reverse burden of proof for employers, which means that you're always guilty and you need to prove yourself innocent when there is a claim. And that's the, I suppose, the shame about the whole system, and why documentation and your legal foundation is so important, and also the process and steps you take with your staff members when you have to change, consult, discipline, etc. So there are more questions. We'll respond to those individually. Corrina, I just want to say thank you so much for your time today and your knowledge. It's been amazing. This is all recorded, so we will be sending all attendees a recording. So please look out for that in your inbox. If you do want a contract review, we are offering it. It's not a lengthy process. Please just scan the QR code, and we'll have someone reach out to you so we can book in a consultant, whether it be me or someone like Corrina, that can have a look, give you a few tips and tricks around what you need to correct, and indeed solutions, which is what we offer as well. So thank you very much, everyone, for attending today, and feel free to reach out to us directly. And Corrina, thank you again. That was brilliant content.
Thank you. Thanks, everyone.
No worries. Have a great day, everyone. See you.